Hello, America, and welcome back to the Gulf War Advocate. And today we're going to have a special guest talking about PACT and what veterans will need to do regarding filing claims and stuff like that. But before we get started here, before I even thought about doing this podcast, I was filming some episodes for a TV show that I was going to do on public television. And I was able to interview two widows whose spouses passed away due to their exposure to burn pits. And I don't want those interviews to go to waste. So I'm going to post those on the other feeds to where you can do the playback and watch those interviews, because there's some awesome content there. And I believe those interviews will help other widows out. So we'll go ahead and get those posted and go from there. And today we're going to talk quite a bit about the PACT Act. And we have a special guest today. His name is Kerry Baker, and he is a service-connected combat disabled veteran who was in the Marines from 1987 to 1998. And he was deployed to Panama, Somalia, Persian Gulf War, and he is now an appellate practitioner. So he has agreed to come on and talk a little bit about the PACT Act and discuss what veterans need to do as far as filing their claims, and spouses and widows, what they all need to do. So please welcome Mr. Kerry Baker. Hi, Kerry. Welcome to the show.
Hey, Tim, how you doing? Thanks for having me on. I appreciate it.
I'm doing pretty good, and you're very welcome. Thank you for coming on. And there we go. And first off the bat, I know this doesn't pertain to much that you do as a legal practitioner, but I've been noticing an onslaught of ads on TV, radio, social media from a lot of different law firms concerning Camp Lejeune. Now, I know Camp Lejeune is mentioned in the PACT Act, but what exactly is covered in the PACT Act as far as Camp Lejeune goes?
So, for eons, military members have not been allowed to sue the government under any circumstances, really, when it comes to their service. The Camp Lejeune, what had contaminated water from the 50s up to the late 80s, from a few private facilities like a dry cleaning facility off base. There were leaking chemicals into the groundwater that got into the base's drinking water. Things like TCE, PCE, vinyl chloride, benzene, arsenic. Not stuff that you typically want in your drinking water.
Right.
And as it came out years and years ago, apparently the government or some parts of it were aware of it and didn't tell anybody. And so that didn't go over well, as you could imagine. And a lot of these people that lived on the base, they were drinking that contaminated water, but so were their spouses, so were their children, so were their mothers who were having babies, so the children were getting exposed before they were born. And it's caused a lot of problems. And a number of years ago, VA did Congress pretty much created, so put it shortly, there's presumptions in place now for a number of disabilities that if you, as a veteran, get some of those disabilities, VA will presume they're related to your service. Things like Parkinson's disease and a few cancers. It's not a long list, but it's, what's on the list is fairly severe. Now, that only applied to veterans. So the big question was, what about the dependents? Because they didn't have veteran status. Prior to making the presumptions of service connection for those diseases, Congress had passed a law that allowed those dependents to get health care under certain circumstances for certain diseases. And we don't really need to get into that, um, but that was pretty much the extent that you could go. For reasons I'm not completely aware of, in the PACT Act, they added a clause in the PACT Act that's really got nothing to do with the rest of the PACT Act. It allows those same people, be it the veteran, their spouses, their children, to bring a lawsuit against the government. Um, and the PACT Act defines that lawsuit has to be brought in to a federal court in North Carolina, which is where Camp Lejeune was. So anybody that is affected by that, that's where they have to file that lawsuit. That is not a VA issue, so to speak, because that is not that's filed in federal court. It's not filed with the VA. And so, and that notion, and that's why you see a lot of these law firms with the ads, because you have to be licensed to practice in the court. You have to have a law degree in order to be licensed to practice in the court. Uh, my understanding, I could be wrong on this, but my understanding is, this is you're going to have a lawyer arguing against you. You're going to have this, a certain burden of proof that is possibly higher than VA's burden of proof. So, you as an individual, there's been some, like you and I discussed off the record a little bit. A veteran might be able to go in there and do that.
Mhm.
I kind of doubt it, because it's you need some legal experience to do that. Um, but the law firms see it as, they could represent 100 veterans, 1,000 veterans, and try to get all their benefits. So you're going to see, because you already are, um, commercials that are geared towards, you know, taking those lawsuits into federal court. And there's some discussion about what they're charging. Um, but for veterans, it's important that veterans know when they see that, that is not for representing disabled veterans before the VA. Okay, because if it is, or if it was, then that's illegal. VA does not allow. You mentioned people are charging 40%, and
Yes.
that, if you file a class action lawsuit or file a tort claim, personal injury claim in civilian court, odds are you're going to pay 40%. That's kind of the 30, at least 30, if not higher. Sometimes that goes up depending on how far the case has to get appealed. Um, so those fees can go up, and that's, you're going to see that, but that shouldn't be interpreted that's what the PACT Act is doing for
Mhm.
veterans who need to file claims for these benefits. That's completely different. When it comes to the burn pits, the herbicide related issues in the PACT Act, those claims are filed with the VA. All right. Now you can have a representative do that for you. I mean, I work for a law firm. We do that all the time. A veteran can choose to have us do that, or a veteran can choose to file it on his own. For these presumptions, you should not. You're right. You should not need a law firm uh, or the like to help you get some of these benefits. Now, so in other words, if you had cancer, lung cancer, for example, and you served in Iraq or Afghanistan, this law, at least going forward, all right, it's going to provide you presumptive benefits for that disability. And if it works right, if VA implements it right, there should not be a fight to get those benefits. Now, if you've been fighting your claim for a long time, so you've got a claim pending for 2 or 3 years, or 5 years, or 10 years, um, the PACT Act is going to affect that claim going forward. All right, with the exception of widows or surviving spouses, it's not going to affect that claim retrospectively. Um, and look, I handle those kind of cases all the time. Um, and have done so for years, and to include other types of exposures. Um, and when we do that, we charge from 20 to 30% retroactive benefits. But those are claims VAs deny. Those are claims without our help. In 99% of cases, those vets are not going to get those benefits. Our fees don't go up. Whether if we represent a vet at 30%, and I say 30, let me clarify some stuff. VA rules do not allow agents or attorneys to charge more than 1/3. Now, most that I know that are reputable charge 30% max. They don't have to charge 30; they could do 20. We have several cases that we charge 20%, just for internal reasons. Maybe it's a hardship on a widow. We don't want to charge 30%. We only want to charge 20. Now that's just back pay. Okay, so if that means we win the case, uh, our fee is, if we're charging 20%, our fee is 20% of the back pay. Nothing going forward. All right, and that's how it has to work. Anything else is kind of unlawful. There are some firms out there that will stretch the law and say, well, we want 10% of your benefits going forward, or something like that. You need to go the other way. That is not legal when you're talking about representing disabled veterans before the VA. All right, but if you're the Iraq veteran, Afghanistan veteran, or Thailand veteran, or and you get, a year from now, you get a disease on this list in the PACT Act, you should be able to go to VA, file a claim for it, and get benefits without having to hire a firm or an agent or an individual. Now, you can, that's up to you. You might not want to deal with it yourself. You might want the help, or maybe you get benefits and they lowball the rating, right? And you want to fight an appeal to get a higher rating. At that point, you have the choice, as you should, to seek representation of your choice, or go it alone. And I think that's a valuable option there, because there was a time when veterans could not get representation, not good representation, at least. And I'm talking about before VA. I'm not talking about in private civilian court somewhere. I would take some of those commercials with a grain of salt. Before, you very well might need legal representation to seek those benefits in that federal court for Camp Lejeune. Uh, but there's a lot of people out there that's going to be handling that. Hill and Ponton's going to be doing some of that. So who you choose is going to be up to you. I can't advise. Do you go with these large firms doing large class actions? That's going to be a personal choice, and probably beyond my expertise to advise one way or the other. But when it comes to the VA benefits, I can pretty much answer all those questions for you.
All right. Now, concerning the PACT Act, if a veteran filed a claim, let's say 5 years ago, and it's still pending,
Uh-huh.
will they receive back pay for that, be retroactive, or will it be from when the PACT Act actually goes active?
If it's a live veteran, all right, as opposed to a surviving spouse, then it will act like most other laws act, just about all other laws act, and that is from point forward. All right. So if the PACT Act says a certain benefit will be effective October 1st of 2022, for example, then that veteran, as of that date, could get that benefit. Now, it doesn't mean they're going to get it on October 1st, 2022. Let me back up and say, my understanding is, and this could change, VA is got a lot of tooling up to do before they can put some of this into play. What I've been briefed on is they plan to start adjudicating these cases around the first of the year. That doesn't correlate out to the effective date. Okay, so if the act says the effective date for a certain benefit, like just take lung cancer and burn pit exposure, if the act says that's going to be October 1st, 2022, even though they might not get to rate in that case till January or sometime, the benefit will go back to October 1st, 2022.
Okay.
Now, if you've been fighting that for 5 years or so, It's not going to go back that far because the law just operates forward unless the law carves out an exception. Right now, it carves out an exception for surviving spouses here. We can get into that when you're ready. Um, but if you've got that claim going for 5 years, or 6 months or 6 years or whatever, that's take the same claim, say lung cancer related to burn pits. Right now, before this law goes into effect, well, I should say the day prior this law was signed, just make it easy. That's a
Mhm.
direct service connection claim where you need the event in service, the diagnosed condition, and a medical nexus between the two. What's the hard part in most of these claims is that middle, the medical nexus between the two. VA is not training their folks very well. They never have. They're raters. I could go on and on about that. But after this law comes into effect, that then becomes a presumptive benefit where you don't need that medical nexus between the two. You still need to show an event in service, which in that example would be the burn pit exposure, which
Mhm.
is going to be a given if you were in Iraq or Afghanistan or a number of other places. And obviously, if you've got lung cancer, you're going to be able to show the diagnosis there. That act is going to do the rest, right? The act is going to say, all right, we're going to presume that A caused B and grant you benefits. At that point, it's going to be a ratings game. I don't mean game per se, but it's, do you rate it at 10%, 100%, somewhere in between? That's going to be a case by case issue. Um, Everyone's going to be a little bit different there. But you still might have to fight for that direct service connection claim if your claim's already been pending prior to this act. And my advice is make that fight, keep that fight up because those are winnable cases. All right, they're hard in some circumstances, but they're very winnable. Uh, you might need representation, you might not. That's a personal call. But I would like to think that the passage of this act would somehow affect those direct service connection claims that were pending prior. And I say affect, VA still has an option or a duty, not an option, to help a veteran assist the development of his claim or her claim. Part of that's getting VA examinations, getting medical opinions. Uh, I would like to think some of those medical opinions, maybe more, would come out positive because of this act than without it. Now, I'm speculating there. Um, but by all means, keep that fight up, all right, because it's worth it. If you've had cancer for 2 or 3 years and VA's been denying your case, don't just accept those benefits going forward. Granted,
Mhm.
it should be much easier now, but keep fighting that case retrospectively. That's a lot of back pay they could owe you. It's just so the
Right.
pact is not going to end all of that.
Mhm.
Um, what it will end, that same vet doesn't get cancer until 2 years from now. Okay. Then they
Mhm.
go and file that claim. Then and it should be granted from day one. Uh, and it shouldn't be a fight to get that granted. And and I don't think we've seen the brunt of these sicknesses and cancers yet. I
Right.
just I think the exposures were too great. I think we're already seeing them at very young ages, but I think it's just going to get worse. That's my opinion. I hope I'm wrong on that.
Right. Now, me being a Gulf War veteran,
Mm-hmm.
I was I had to fight the VA constantly concerning Gulf War syndrome.
Right.
And I was always diagnosed with one thing or another. So I
Mm,
kept getting denied. Now, with Gulf War syndrome, that's if I'm correct, with the PACT Act, there it's no longer going to be a mystery illness. The presumptives are actually going to fall or be applied to Gulf War syndrome as well. Is that correct?
yes and no. Okay. The act when we're talking, and I say burn pits, I'm using that term kind of universal.
Mhm.
Let's say Gulf War exposures might be a better way to say it, and that includes everything from Iraq, Afghanistan, Egypt, Jordan, Syria, Israel, all that stuff. I think it's Israel, but all of that starts from August 2nd, 1990, which is when the first Gulf War started,
Hmm.
all the way up to the present. So, in that regard, the answer is yes. Okay, where if you had unexplained breathing problems and they called it COPD, or unexplained breathing problems and they called it chronic bronchitis, or us Gulf War vets, I've been through that ringer. All right,
Yeah.
you got something wrong, they're not sure what it is. You get diagnosed with something, and that's just enough for VA to deny the claim because you've been diagnosed with something. Whereas before you had been diagnosed with something, it was just enough to deny the claim because you weren't diagnosed with something.
Right.
Uh, I could go on and on about Gulf War claims
Mhm.
under the current Gulf War regulations and statutes. They are some of the most complicated things out there. And I like handling those cases because I'm a Gulf War vet. I know how hard it is to win those. I've got a pretty good head wrapped around the issue. Uh, but when I start talking about it, I usually get glares and deer in the headlights look, and that doesn't matter if I'm talking to a VA employee or an attorney that should be qualified in this. It's just complicated. But this PACT Act, all right, all those cancers, all those breathing problems, if one of those diagnoses that you've been fighting is COPD, if that's what they're calling it, maybe it's not, that diagnosis is going to be presumptive for Gulf War vets going forward. So, to that extent, if you're fighting for something that's on this list, it applies to Gulf War vets from the first Gulf War, just like it applies to Iraq and Afghanistan vets. And that is fantastic. All right,
Mm.
because that's we're 30 plus years
Right.
past the first Gulf War, and this is the first bill that's had any real teeth for Gulf War. And I say real teeth because the Gulf War rules and regulations, statutes, and if you want to look them up, it's 1117 in the statute, 3.317 in the regulation. They're complicated. That's what you were referring to, all the claims that you've been denied for.
Mhm.
Uh, those are done under Gulf War rules. Now, what is a Gulf War disability? It's two things. It's either an undiagnosed illness or a chronic, medically unexplained chronic multi-symptom illness. That we're talking about prior to the PACT Act now.
Mhm.
All right, and that could be a lot of things. What is an undiagnosed illness would be joint pain, arthralgia. It wouldn't be arthritis, right?
Right.
Arthralgia is joint pain. Neuralgia is nerve pain. You got a set of symptoms that they just can't tag a diagnosis to. They don't know why you have it. That could be an undiagnosed illness claim. Well, let's say you have rheumatoid arthritis. Well, let me back up. The Gulf War regs and rules do provide a presumption for fibromyalgia, irritable bowel syndrome, to include functional gastrointestinal diseases, and what I say, fibromyalgia,
Mhm.
IBS, and um, uh, chronic fatigue syndrome. If you're on a blank there. Unfortunately, a lot of those still get denied, even though they're presumptive,
Right.
because the examiners and the raters, they just 30 years later, they still don't get it. All right. The examiner will
Mhm.
say fibromyalgia has not been linked to Gulf War service. Yes, it has.
Yeah.
I've got a claim. I saw a claim just the other day. Fibromyalgia was denied in a Gulf War vet, even though it was diagnosed because we don't need to get into it, but that should not happen. All
Right.
right. But those are the easy ones. Well, let's say you've got the rheumatoid arthritis. Well, now that's not an easy one. So, what does multi-symptom illness mean? Medically unexplained chronic multi-symptom illness. Basically, that is a diagnosed condition of unknown etiology or pathophysiology. There's been a lot of litigation on that phrase. But it basically means now that litigation's over, it's taken a long fight to get even this narrow definition. That's a diagnosed condition, so it doesn't have to be undiagnosed. So
Mhm.
the rheumatoid arthritis would be a diagnosed condition of unknown etiology for that specific vet. Doesn't mean all cases of rheumatoid arthritis need to have an unknown etiology. Now, in that case, it's not going to be an unknown pathophysiology. They can test you for rheumatoid arthritis, They can look at that test and go, yep, that's a marker for rheumatoid arthritis. That's pathophysiology. That's all that is. Okay. If it wasn't for pathophysiology, they probably couldn't diagnose anything. That's
Right.
not the same as etiology. What caused it? There are some things that cause rheumatoid arthritis. And again, that's just an example. If your grandfather had it and your mother had it and your sister has it and you have it, it might be genetic. Okay. If none of your family has it and you don't have any genetic markers for it, but you have it nonetheless, its etiology in your specific case might be unknown. Okay. If that's the case, you have a winnable issue under the first set of Gulf War rules. But good luck. Uh,
Mhm.
Winnable because if they were to apply the law to the facts without question and do it objectively, exactly the way the courts have interpreted it, you would win that case. Uh, it is not that simple. Uh, so those kinds of cases, all right, that aren't going to be covered by the PACT Act. If you're still fighting those unknown kind of complicated issues, unless it's diagnosed as something that's on the PACT Act, any of those cancers, any of those breathing issues, or something in the future that because VA's got to do a lot of research because of this PACT Act, they got to look at a lot of things. The PACT Act does help improve the medical nexus uh, uh, element, especially with Gulf War cases. Okay,
Mhm.
which that was really pathetic before. We hope it's going to improve now. So there's aspects to this that will help Gulf War cases that aren't expressly applicable to this bill. There's in other words, there are parts of this bill that's going to help that. We hope if VA doesn't fight it.
Mhm.
Uh, at the same time, the presumptions they're going to apply to Gulf War vets just like they're going to apply to Iraq and Afghanistan vets. And that's why I say 30 years, 30 plus years later, it's about damn time.
Right.
Um,
Now, I had filed my first claim almost 28 years ago,
mm,
and it took 25 years from that day to finally get my service connection.
yeah.
But what I switched my thought on that. Instead of trying to go from Gulf War syndrome and everything being a mystery and no diagnosis and all that, I started telling them, well, I was exposed to burn pits. I was exposed to the oil well fires. And
Hmm.
then I get diagnosed with constrictive bronchiolitis, and boom, 25 years later, I finally got my service connection.
Yeah.
Um, so I'm glad the PACT Act is going to, take away some of the fight as far as that exposure goes for Gulf War veterans.
Right.
But um, so with the diseases that are not on the presumptive list with Gulf War, they're still going to have to fight as far as like a non-diagnosis or as
Yeah.
far as them being, as far as how they got the disease to begin with or the illness.
To some degree, yes, yes. If you have you're a Gulf War One vet, you have a disease that's not on the PACT Act, uh, and you've been fighting that for a while, you're probably still going to have to keep fighting that.
Yeah.
But once the thing gets ramped up to full speed, we're hoping there are elements in the PACT Act that would nonetheless benefit that kind of claim. Some of the oversight provided to examiners, the training necessary for examiners to know how to do the opinions correctly. All that's kind of yet to be seen on how VA implements that. But my hope is that that somehow helps some of these rather complicated Gulf War cases. But
Right.
we're just going to have to wait and see how that plays out.
Now, I listened to a podcast you were on earlier today,
Hmm.
and one of some of the information you were giving, I thought was extremely important, and it was overshadowed while we were all advocating for the PACT Act and everything as far as spouses go.
Hmm.
Um, Surviving spouses. Now, a lot of them, their survivor benefits were being denied.
All right.
Now, with the PACT Act, it, hope for them looks extremely promising.
there's really good hope for them. And so, like I said earlier, most of these new laws like this operate point forward, unless there's a provision in the law itself that says there's a portion of it that's going to operate retroactively. And for surviving spouses, that's exactly what we have in the PACT Act. And that's just, I know veterans have been fighting their cases for a long time, or, probably not going to be all that happy that it's not going to guarantee them back pay. But if your veteran spouse has died, you probably been in a hurt locker for a number of reasons, especially if VA then turns around and denies you surviving spouse benefits, DIC, which stands for Dependency and Indemnity Compensation, which is what a surviving spouse gets if the veteran died of a service-connected condition, or died in the military, or the death was contributed to by a service-connected condition, or if the vet was already 100% for 10 years or more. I mean, there's some nuances in there, but your typical surviving spouse that's affected by this bill, say a Iraq veteran, just using this as an example, and understand that what I'm explaining here applies to the whole bill. All right, not the Camp Lejeune stuff, but
Right.
all of the presumptive conditions, be it for herbicides and be it for burn pits. Okay, this applies to the surviving spouses based on our reading of the bill universally. And what that means is, take an Iraq veteran who died in 2005. Okay, this is kind of the example I used earlier. And say he died of lung cancer after coming back from Iraq or Afghanistan. The widow or widower files a claim for DIC. Upon the death of the veteran, VA says, nope, there's no evidence to show that that lung cancer was caused by burn pits, and that widow is denied benefits. All right, let's just say whether she fights it or not. Okay, whether she's been fighting it or not. Let's say she doesn't fight it. She just gets discouraged and gives up. Uh, Maybe filed a claim here or there. Since then they keep getting denied, or maybe not. Maybe that's the only one she filed. You can come in now with the PACT Act, refile for DIC, ask that her original 2005 claim be readjudicated in accordance with the PACT Act. And this act tells VA to go back and readjudicate that original claim, thereby potentially giving her those benefits all the way back to that first claim. Okay, and that is tremendous for surviving spouses.
Yes.
When you start parsing that out with herbicide exposed vets during the Vietnam era, well, you can go pretty far back with some of that stuff.
Right.
So it's very important. And so what a spouse would need, what a surviving spouse would need to do is come back into the VA, and most likely, if you've been denied in the past, and this could change, we don't know. We're just assuming on the way the system works now. Probably need a supplemental claim form, which is a 20-0995. It's easy to fill out, it's relatively short, and reapply for DIC, uh, and ask that those retrospective benefits be restored. Retrospectively. Now they're not going to start processing those cases as we understand it till the first of the year, but when they process them, uh, it should result in a good amount of back pay depending on the circumstances of that case.
Yeah, that's definitely some good news for spouses, because I've met a lot of widows while advocating for this bill, and they were all, well, actually, all their stories were pretty similar. It's the
Mhm.
spouse died, VA told them, sorry, we can't help you. They're losing their houses, their cars, and everything, and this is definitely going to be a big help for them.
Yeah.
Now, one thing that I was thinking about here just a moment ago is when a veteran does file under these, at the same time, they should also be filing or registering on the burn pit registry as well. Do, would you agree with that?
I Yeah, I don't disagree with it.
Okay.
And I only said I think the burn pit registry is probably a little underutilized, maybe.
Hmm.
But the problem I have with it is I've yet to see a registry in VA, because look at the Vietnam registry, been around for a long, long time. Uh, I've rarely seen the registry be a tool that affects benefits. Um, and I think it's because how VA uses it. Now, there's great potential behind it, and you stand to lose nothing whatsoever by signing up and filling out the registry. I would suggest do it. It's just whether it's going to impact your case down the road, it may not. Now, if VA, because VA's got to do a lot of research because of this PACT Act,
Hmm.
I would say the PACT Act probably makes it more important to sign up for the registry, because I hope at least they use part of what's in that registry for some of the research. Uh, and so it would become more useful to those researchers if more people would sign up for it. Um, and so, but historically, if you look back at the Agent Orange one, or even the Gulf War registry, I don't, and I might be wrong on some of this, but I don't know of a situation where it was the linchpin to effective benefit down the road, either because the researchers didn't use it as such, or because it wasn't tooled in a way to allow them to use it very good. Uh, but researchers, they like to define their own parameters, um, and they might, if they were doing it themselves, might define parameters differently than what that registry is set up as. I don't know. I mean, this PACT Act does open up the registry to some degree, and I think makes some improvements on it. Uh,
Hmm.
and so I'd say, yeah, go ahead and sign up for it. Definitely sign up for it. Just don't expect the fact that you're signing up for it it's going to make a huge difference in the claim. The hope is that it gives the government, whoever's doing this research, more tools to figure out, if additional illnesses need to be added. It can be used good for that. I just haven't seen VA use registries that much for it. So I hope this one will end up being different. Um, I, I I would prefer there to be compartmented registries. That is just my opinion here.
Hmm.
Nothing more, nothing less. Uh, for example, the burn pits. When we're talking about burn pits measured by the acre, uh,
Right.
we're really talking about Iraq and Afghanistan post 9/11. When we're talking about 1,000 oil well fires and God knows how much benzene in the air, we're talking about Gulf War One.
Right.
Uh, so there is a not huge but slight difference in the exposures. Uh, but the registry includes both groups to include anybody that served in between those time frames in that area. So if you could have been over there in 1998, before, after the Gulf War One, before 9/11, where there wasn't really any real fighting going on, and let's hope to God that the environment was a little, the air was a little cleaner. Well, that group could dilute uh, the burn pit registry, particularly for, if you're comparing that group to people who served post 9/11, who were definitely exposed uh, to those large burn pits.
Hmm.
How that's a theory of mine, just based on some experience. Uh, I'd like to see a burn pit registry that that includes people exposed to burn pits,
Hmm.
and not people exposed to something else. Uh, I just think it would be more helpful that way. It wouldn't get diluted. Uh,
Right.
but again, that's me speculating. But I agree with you. Sign up for the registry, and let's hope the VA finds a way to use it to the benefit of veterans in the future.
Right. Now, I also want to make a note that when registering on the burn pit registry, be resilient when you do register, folks, because sometimes people are getting kicked off the registry, and you need to file re-register again. So just stay resilient, keep checking to make sure your name's still on that list. If it does come off, re-register. Because my theory is the more people that register, I think the faster the VA is going to improve the claim system, and because then they're going to see how many people are actually um, ill from their
Yeah,
exposure.
that's a good point. That I didn't think about that. That's a very good point. I know there are a lot of people out there sick that have not registered for it.
Right.
I know that for a fact. Uh, but you're right. I mean, if it's got 350,000 versus 3.5 million names on it, yeah, 3.5 million names on it, that's going to get VA's attention
Right.
more than 350. 350,000 should get their attention, but I mean, let's face it, a couple of million is going to get their attention more than that. So yeah, another good reason to sign up for it.
Now, I also want to make a point here too. Is when you do register onto the burn pit registry, folks, check that little box saying you request the physical.
Mm.
That research is going to be helpful to us down the road. It may not help your claim right away, but it, as far as research goes, that little physical that they do is going to be very helpful for us down the road. So please check that box to make sure you get that physical. It's free. It's not going to
Yeah.
cost you anything, and it helps you get into the system faster.
And I could add something to that.
Right.
Historically speaking, I, I actually have. So let me retract some of what I said. I have seen Agent Orange registry examinations. All right, because in that registry you can get an Agent Orange physical, just like in this one you can get a physical, and it goes into your record, in your VA healthcare record. It may show something, it may not. Right, but I have seen it show things on the exam uh, that were not presumptive. Okay, not yet. Right, and I've seen those same diseases become presumptive down the road. Talking about Agent Orange here. Now that's a little bit different with Agent Orange with the Niemer court case and everything. Uh, and because the Agent Orange exam picked those conditions up when they weren't presumptive and later made presumptive, if depending on how NEMA applies, if those things were in the file, if you were filing claims at the time, uh, VA was on the hook to go back and consider that a claim. Now, that's not going to work with the PACT Act like that because that's specific to NEMA. The point I'm making is you don't know what VA is going to add in the future. You may get a diagnosis. They may diagnose something you already know you have, but it goes on that registry exam. That it won't hurt your case. I can't imagine how it would, but there is a chance, depending on what happens in the future, with what new regulations come down, with what new laws passed, new presumptions that are added. There's a chance it could always help you. Just getting it in your record. I've seen that happen on plenty of cases. So, I wouldn't bank on it by no means, but yeah, get the, like Amy said, it's a free examination. So, uh, I've also seen people that thought they were in good health come up with something quite serious on those exams, and it might have saved their life. Uh, so yeah, don't pass up a free exam if somebody's going to give you one.
All right. Now, one thing too is we had discussed Agent Orange a little bit ago, but are there other agents that were used, such as like Agent Pink or Agent Black, that sh- our veterans should be using when they're filing their claims instead of just using the catch-all of Agent Orange?
Um, yes and no. I, I like to see the terms herbicide agent because that's what's in the law. If you look at 1116, which is the statute where the Agent Orange Act is codified, if you look at 3.309 and 3.307 in the regulations that talk about herbicides, you will see they always use the term herbicide agent.
Okay.
And they don't say Agent Orange. It's not in. It's not in the statute or the regulation. Most people wouldn't would think differently. Now it defines herbicide agent. Right. For example, in talking about Vietnam. Right. Now this is going to apply to all the areas that the PACT Act opens up because it doesn't specify Agent Orange. It says herbicide agent. So right now in the VA regulations, and I argue cases like this all the time. VA balks at it because it's a long story. We can get into it if you want. We don't have to.
Mhm.
But 3.309 lays out all the presumptive disabilities for herbicide agents as well as some other things. And in that section, it says if you were exposed to a herbicide agent as defined at 3.307, it gives a subsection, and you get one of these disabilities, and you were exposed to that herbicide agent on active duty, then that disability will be presumptive. So then you go over to that regulation and says it is where it defines herbicide agent, and it defines that herbicide agent as 2,4-D, 2,4,5-T, and its contaminant dioxin, which is 2,3,7,8-TCDD, picloram, cocodelic acid. Those are the herbicide agents listed in VA's regulation. Those same agents are what made up Agent Orange, Agent White, Agent Blue, Agent Pink, Agent Purple, Agent Green. Now, most people hear about those are the rainbow herbicides. Okay,
Mhm.
most people hear orange, white, and blue because those are the ones that were used the most. Purple, pink, and green, they were used earlier on in Vietnam, but they still were comprised of those components. So, for example, Agent Orange was a 50-50 mixture of 2,4-D and 2,4,5-T. Okay,
Mhm.
that's what it was. To each of those agents were herbicides in their own right. 2,4-D was a standalone herbicide. 2,4,5-T was a standalone herbicide. You mix them together at full strength, you get Agent Orange. And depending on the alcohol base and stuff we don't need to get into, it's not
Mhm.
really relevant. But the 2,4,5-T was contaminated with dioxin, right? Also defined as a herbicide agent. The same dioxin that burn pits put out. Good thing to keep that in mind. Uh, Agent Blue was cocodelic acid, which is about 33% arsenic. Uh, Agent White was a 4-to-1 mixture of 2,4-D and picloram. That's why it says picloram as a herbicide agent in the regulation. So those are your agents. All right. If you're in Vietnam, you're conceded exposed. You're presumed exposed to a herbicide agent. That's it. It's that simple. If you're in Thailand now because of this act, you are presumed exposed to a herbicide agent. Uh, now, what does that mean with respect to the question? Okay, as far as the presumptive issues go, uh, you're considered exposed to a herbicide agent. You don't need to prove one or the other. Okay,
Yeah.
but let's just say you're one of my favorites, a Fort McClellan veteran. The act does not cover Fort McClellan. Uh, I could give you my opinions on that,
Mhm.
but it should. Fort McClellan, in my opinion, is ground zero for herbicide use inside the United States. It was home of the Army Chemical Corps. The Army Chemical Corps is the ones that sprayed herbicides in Vietnam out of the helicopters and the Buffalo turbines, not out of the C-123s. That was ranch hand. That was Air Force. So, so everyone spraying out of helicopters, or pretty much everything but a C-123, was probably from the Army Chemical Corps and trained at Fort McClellan. Right.
Okay.
That's also where they did all the other tests. That's where the Monsanto plant was. I mean, it was not a clean place to be around. Now, there are records out there that show a tremendous amount of use of picloram in the form of Toradon 101. And I say this to help answer the question. Okay, if
Mhm.
you could benefit in that scenario by claiming exposure to Agent White via Toradon 101, which is the picloram, which is the agent, the active agent in there. Reason being is because Toradon 101 and Agent White are the same thing. No difference whatsoever. Uh, Agent White was Toradon 101 in a 55-gallon barrel with a white stripe around it. Now, you listen to VA, they will say, no, Agent White was a tactical herbicide. Toradon 101 is a commercial herbicide. It's bullshit. Okay. I don't mind telling VA it's bullshit. Anybody can look it up. It's the exact same herbicide. So, in that respect, if you could show if VA was to apply the law correctly, and they run from this one, and they're still running, we don't intend to let them run much further. But if you could show to VA that you were exposed to the Toradon 101 on Fort McClellan, then technically, according to the law, you've been exposed to a herbicide agent via picloram, which is in the regulation, which is Agent White. All right. Now, try to get that past VA and their readers, and they'll be what? It's not presumptive. My mind doesn't work past the presumption. Okay, and I refer to that as presumptive groupthink. Because they can't get past a benefit that's not a presumptive in some of these exposures. And so, well, the PACT Act makes sure that they get that presumption now on a lot of it. So they don't have to think that far, but there are still other cases like Fort McClellan where they're going to have to think a little harder than they've been accustomed to doing.
All right. Now, I've been getting a lot of feedback from veterans who might be affected by the PACT Act, and they think that the presumptive list is solid, that nothing else can be added on later on. Is that a true assumption, or is there something in the bill where they can add more presumptives later on?
Yeah, that is not a true assumption. Now, it is solid, in my opinion. If you're just asking, are these, is this a good list? Is this going to help a lot of people? This is a tremendous list, right?
Yes.
Anybody knocking this bill because it doesn't cover something you're affected by, I'm sorry about that, but that does not make this bill a bad bill. It is not this bill's fault. This is a great bill. Now, can VA add things to it? Absolutely. Will they? I wouldn't hold your breath but the bill does set out a new process for VA to consider adding new presumptions. Okay. That's a process they're going to have to follow. They're going to have to look at the results of whatever research they do. And yes, it might end up with more diseases added down the road. Having said that, not to scare people, this bill also has provisions in it for VA to take things off that list. Right. Now, what's the likelihood of that? Well, one, it sets out a process that they have to follow if they're going to do that. They're going to have to come up with very sound medical evidence that a particular thing on this list has nothing to do with these exposures. Right? I find that, again, my personal opinion here, I find that is going to be extremely difficult, because if you look at the burn pits part, just based on what we know was detected in the air around the burn pits, there is not a target system part of the body that's left untouched. Out of all these chemicals, there are, whether it be the reproductive system or the immune system or the respiratory system or the nervous system, every system in the body is touched by these toxins. In other words, benzene has somewhat specific target systems. So you get exposed to benzene, certain systems in your body are going to be more vulnerable to it than other systems. And so the diseases that affect that system, like leukemia, all right, you're going to be at a much greater risk of getting that than if you weren't exposed to benzene. But when you look at all of these chemicals, there is not a body system out there that we have that's not a target of some of these individual chemicals. So what happens when you add them all up? I think for that reason, it's going to be hard to come up with good research that shows burn pits, does not cause lung cancer or does not cause reproductive cancer. Uh, that's a tall order,
Hmm.
and if they try that, I imagine some of us are going to be watching. Uh, in fact, I know some of us are going to be watching,
Right.
and they're going to have to justify it. The public is going to get to comment on it. I mean, that's not going to be an easy task. So I would not worry about that.
Hmm.
I just wouldn't. I don't think VA is ready for that fight.
Right.
They have a hard enough time getting the stuff implemented the way it's written. If they go down the road trying to pull back the reins on things, uh, they're in for a harder fight than if they were just by going along with the bill and implementing it the way it's written. If that makes sense.
Yes, it does. And got one last question here for you, Kerry. And we've been getting a lot of questions about contractors and who are in the AOR. Do you have any advice to them? And are they covered under the PACT Act?
They unfortunately they're not. Um, and I've gotten that question for I don't know the past 20 years, almost 20. Um, and they're not because while they're exposed, they're not wearing the uniform. We're talking about veterans. You need to attain veteran status, all right, to get benefits through the VA. When you're not in uniform, you are not in veteran. You can't get veteran status as a
Right.
civilian. Uh, doesn't mean there's not ways a civilian can go about with. They're going to have to go through their employer, through the systems that aren't available to veterans. Okay, VA is available to veterans and only veterans, maybe with the exception of Camp Lejeune now. Everybody else, they have other systems to go through. It might whether they're harder or easier, I can't speak to that. Whether they have to
Hmm.
go into private court, sue their employer, workman's comp. I mean, there are things out there that are meant for that. Um, I'm not an expert in that area. I won't claim to be. Um, but yeah, contractors, and I understand, because many of the contractors were former military. Um,
Right.
you know, but now if you were a military personnel in Iraq, and then, as an example, and then later a contractor in Iraq, then forget about the contractor stuff. Go with the military
Hmm.
as a veteran and apply for these benefits. The fact that you were there as a contractor should not eliminate your eligibility. Now, you might have other avenues you can still seek as being a contractor, um, but if you were never in the military and you're just a contractor over there, yeah, you're probably going to have an uphill battle. I'm not familiar with that battle,
Right.
but this bill won't. Now, could it help if you go into court, outside of the system, outside of VA, whether it's some kind of tort claim or something like that, could this bill help? Maybe. We're talking a legal proceeding. I'm not that familiar with, but uh, as far as getting benefits from somebody outside the VA, it's not going to help that.
All right. All right, Kerry, I want to thank you for coming on today. Hopefully, our veterans learned a lot today, considering the PACT Act and what they should do. And later on today, I'm going to have another guest. We're going to have Tim Jensen from Grunt Style come on and explain what Grunt Style is and talk about advocating for the PACT Act some. And well, hopefully, we see you all later on today as well. And
All
hope
right. Thanks, Tim. I appreciate you having me.
You're very welcome, Kerry. I appreciate you coming out. It was an honor getting not only meet you, but to talk with you as well, sir. And I hope you enjoy the rest of your afternoons.
All right. Thank you. You too.
You're very welcome.